Namaskar from the e-platform of Faculty of Law, GLS University. Greetings from Faculty of Law, GLS University. It is a very special and precious day, so very green morning to all of you as it is the conference that is Green Conference for all of us, international conference. Very warm greetings on this special occasion on this pleasant green morning. August is the month of independence of India. August is the month of foundation day of Faculty of Law at GLS University. And it is a very special occasion as 75 years of independence of India is getting completed in this very year. So once again, greetings for that. And in India, everything begins with a small prayer. So we will be having e-prayer with which we will start. Thank you. With the e-prayer and e-deep prakati, a lightning of lamp, which says that let everything be begin with blissfulness. We are starting this morning an inaugural ceremony of this most awaited international conference on climate change, governance, and law. I would like to request Dr. Mayuri Pandya, Director of 5 Years Integrated Law Program and an environmentalist herself, who is holding a very good and pioneer position in state and national level in the field of environmentalist as an environmentalist to offer her welcome address. Over to you.
Thank you, Payal. या देवी सर्वभूतेषु शक्तिरूपेण संस्थिता नमस्तस्यै 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 नमो नमः. I bow down to Vidya Shakti, present in one and all, present over here on screen and virtually everyone who has joined today with us on the for the inaugural ceremony of the climate change and climate change governance and law. I welcome on behalf of Faculty of Law, GLS University, each one of you who have joined today. Today is a very special day for GLS University. The reason being that we are celebrating Azadi Ka Amrit Mahotsav, when India is celebrating its independence 75 years. So semi-sequential a celebration of the India's independence, and as a part of that, another important event for GLS University as the parent body is celebrating the centennial decade. And third most important event that took place at the international level, the Stockholm Conference. The Stockholm has completed 50 years. So this is these three events has motivated, and being the very responsible stakeholder and being the Faculty of Law, we thought that the best celebration can be by announcing this international conference for providing all the scientists, all the academicians, all the researchers, and all the students a platform where a subject which is the need of an hour can be deliberated, can be discussed. So for that discourse, we have announced this international conference, and I heartily welcome the chief guest of the conference and the keynote speaker, Honorable Mr. Justice Brian Preston. I also welcome Honorable Shri Dr. Sudhir Nanavalli, President of GLS University. I welcome Dr. Pozzo, Dean and the Professor, the Faculty of Law from the Insubria, Como, Italy. I also welcome Dr. Behnasi from Morocco, Professor of International Environmental Law. I welcome each and everyone who has joined us today on this e-platform. Today is a very special day as we are inaugurating this international conference. There are two things very important and common between, because we have Honorable Mr. Justice Brian, and we have our President Sir Sudhir Nanavalli Sir. One common thing when I was just going through Justice Brian's biodata, I saw that Justice Brian got recently in 2018 was awarded uh, PhD degree by the Macquarie University of Australia. So, sir, our honorable president, sir, also received the same year as the honorary doctorate degree from one of the state university for his contribution in education and your contribution as a judge, as an academician. The most important aspect for honorable Mr. Justice Brian, sir, is that he taught environmental law for 30 years. Sir, being practicing environmental law and then being a judge in environment court, and your contribution as a teacher, as an academician, it shows, it speaks volumes. And I think the best of the best chief guest for our international conference today. I heartily welcome you, sir, on this e-platform. One common thing for Dr. Behnasi from Morocco and Dr. Pozo, both are professors and they are the crusaders and they have extensively worked for the cause of the environment. I welcome all of you to this e-platform. As this is the Azadi Ka Amrit Mahotsav and the climate change governance and law is a very important subject. And this is the month, this last 15-20 days has been very, very important so far as the environment is concerned, because the United Nations passed a resolution that the right to healthy environment is one of the human rights. So on one hand we have that, and recently the Union Cabinet of India has come up with the NDC as a common but differentiated responsibility, being a very responsible stakeholder. Once again, with this, I welcome each and everyone, every participant. We have all the participants across the globe, from Afghanistan, from South Africa, from Nigeria, from South Australia, Zimbabwe, Indonesia, Nepal, Bangladesh, Afghanistan, all the participants across India and the other countries. I welcome each one of you for this inaugural ceremony, and welcome all of you, all the students who have joined today. Once again, I welcome each one of you to this inaugural ceremony.
Thank you
Thank
so
you.
much. Thank you so much, Dr. Mayuri Pandya. Now it is the time to listen to a great person, president of GLS University, a prominent lawyer, leading lawyer, practicing at Gujarat High Court, practicing at Supreme Court of India. Law is in his blood and genes, a son of a great father and father of a great lawyer's son. None other than Dr. Sudhir Nanavati, who is also into a great academician, along with being a lawyer, a senior lawyer, and along with that, he is into academics and a great philanthropist, and always encouraging for any new things, any upcoming events, just like this international conference that has been become possible because of his vision. I request Dr. Sudhir Nanavati, President of GLS University, for his presidential and inaugural address for today. Over to you, sir.
Yes, thank you, Payal. Good morning to all. On behalf of GLS University and mine, I take this opportunity to welcome Honorable Mr. Justice Brian Preston, Chief Judge, Land and Environment Court, New South Wales. I also extend my warmest welcome to all the viewers of this session, students, budding lawyers from various law colleges, academicians, research scholars, as well as practicing advocates who have joined us from all over the globe. In my understanding, the topic of today's seminar is not only appropriate but a real necessity which requires interaction with all seriousness and also nudge to wake up every human being on this earth Otherwise, the adverse consequences which our future generations would have to suffer is unthinkable. Undesired change in climate all over the globe has already started, and it is time where necessary steps to save the adverse effect of climate change is to be taken seriously by governments, authorities, NGOs, institutions, and each and every individual. I came across the news a few days back that there was a heavy rain and flood in the UAE, including Dubai, Abu Dhabi, etc., which has not been the case in the last 27 years. In Europe, at the same time, there were the heat waves where temperature went up to 40 centigrade, which was unheard of in the United Kingdom. In India, we are witnessing the same climate change issues during Diwali time, where there are rains and floods in certain parts of the country, and the heat in April to June have almost become unbearable. As Kofi Annan said, and I quote, on climate change, we often don't fully appreciate that it is a problem. We think it is a problem waiting to happen. Unquote. And truly so. We usually wait for big calamities to happen, even though we know that we are already under the increasing effects of climate change. And who is to blame for all this? All of us. And look at the irony of it that the only species created by God who can think, speak, and act upon it is the reason for the destruction of the environmental and the climate change. And hence, we are at the juncture where, as a humans, it is our moral duty and responsibility to create sustainable ecosystem for future generations. Climate change is a hard challenge, but it is be brought in line if government, businesses, and individuals work together. Many people want to do right thing. Many will do the right thing, but people need to be guided by laws and regulations. The environmental rule of law will not just save us from climate disasters, but also improve our lives. Let us abide by the governance laws and adapt our lives in line with these laws, as there is no planet B. Before I conclude, let me congratulate the Faculty of Law, GLS University, and more particularly the Director of the Institute, Dr. Mayuri Pandya, for organizing today's seminar, whose topic is not only a burning problem, but is also affecting each and every human being on this earth. This international conference aims to address the impact of climate change on ecosystems, and for organizing the same, I congratulate each and everyone who have taken pain in organizing the same. Thank you and everyone, and have a nice day. Thank you.
Thank you so much, sir, for your address. Now, in Sanskrit, it is said that Bhumi Mangalam, Udaka Mangalam, Agni Mangalam, Vayu Mangalam, Gagana Mangalam, Surya Mangalam, Chandra Mangalam, Jiva Mangalam, Jagat Mangalam, Deha Mangalam, Mano Mangalam, Atma Mangalam, Sarva Mangalam, Bhavatu Bhavatu Bhavatu, which means let the land, fire, sky, sun, moon, each living entity, the whole universe, body, mind, soul, everything means everything be blissful. That is what it is called Shanti Mantra in India. That is that is offered to Prakriti, that is Mother Earth. As this is the right time of international conference that we wish to unveil Haritamukh, that is the abstract and compendium of all the abstract received for this great conference and all the research papers, researchers, lawyers, environmentalists who have worked hard. It is the compendium of all the abstract received, and the name itself is suggesting Haritamukh. Harit in Sanskrit, Harit means green, Amukh means preamble. That is Haritamukh. This is green preamble which we wish to unveil with the permission of all dignitaries present virtually over here. Brian Preston, sir, shall we unveil that? Sudhir, sir,
Do it.
ma'am. મારો ફોન હાથમાં રાખ. Well, thank you for witnessing and for being there while unveiling Haritamukh Green Preamble, the compendium of the abstract. Thank you so much. We are glad with that. As for that, the Prime Minister of India, Mr. Narendra Modi, also sent the message, and it has really congratulated GLS University by stating the initiative by GLS University to hold deliberations on an issue of global importance during Amrut Mahotsav is admirable. Climate change is one of the greatest challenges facing mankind, impacting millions of lives and livelihoods. The burden of climate change falls the most on the poor and disadvantaged. Indian lifestyle is based on the principle of harmonious coexistence with nature. Sustainable practices have been integral part of our daily lives, and guided by such lofty principles that treat the earth as mother and humans as its children, it is natural for India to take the ideal on environmental issues. We are so thankful to Honorable Prime Minister of India for sending such an inspiring message to GLS University. We are thankful and grateful to him for that. Now, this is the time for our chief guest of the inaugural session, Honorable Mr. Justice Brian Preston, sir. Just to introduce him in a brief, Justice Brian Preston, sir, is the Chief Judge of the Land and Environment Court of New South Wales. Prior to being appointed in November 2005, he was a senior counsel practicing primarily in New South Wales in environmental planning, administrative, and property law. He has lectured in postgraduate environmental law for over 30 years, more than 3 decades. He is the author of Australia's first book on environmental litigation and 142 articles. Book chapters and reviews on environmental law, administrative, and criminal law are also there. He holds numerous editorial positions in environmental law publications and has been involved in a number of international environmental coalitions and capacity building programs, including for judiciaries, throughout Asia, Africa, and European Union. Justice Preston is an official member of the Judicial Commission of NSW, Fellow of the Australian Academy of Law, Fellow of the Royal Society of NSW, and Honorary Fellow of the Environment Institute of the Australia and New Zealand. He was awarded an honorary doctoral degree of letters by Macquarie University in 2018. He is a member of various international environmental law committees and a member of advisory boards. He serves on the governing council and as a vice president of Oceania of the Global Judicial Institute of the Environment and chair of the Environmental Law Committee of the Law Association for Asia and the Pacific, which is popularly known as Law Asia. Justice Preston is currently a visiting professor, means academics is also one of the laws of Preston, sir, visiting professor at Durham University, UK, and adjunct professor of three Australian universities, the University of Sydney, Western Sydney University, and Southern Cross University, and former visiting fellow at Corpus Christi College and Magdalen College of Oxford University, UK. So many things in your head, sir. Judge Brian Preston, and Australia is well known for giving its bold judgments as well, especially South Wales. The recent judgment against social media, Google is also a very popular one. Now it is the time to listen from Brian Preston, sir. Over to you.
Thank you.
Honorable judges. Sir.
Just going to share my screen. So it's a great pleasure and honour to be able to address this important conference on climate change, governance and law. We recognise that climate change poses an existential crisis and that we need ambitious action by governments and corporations to reduce greenhouse gas emissions from human activity. And the goal is to achieve net zero emissions, which is a balance between anthropogenic emissions by sources and the removal by sinks. The Paris Agreement, which many countries, including, of course, India and Australia, parties, sets some temperature targets. That is, that we need to achieve a capping of the increase in temperature, a global temperature to 2 degrees and preferably 1.5 degrees by the time target of the second half of this century, so 2050. Now, both government and the corporate sector have responsibility to achieve these action. But the question is, who is to hold them account for the adequacy of the action they do take, or if they fail to take action at all? And the answer is, it is, of course, the courts. So what I propose to do in this lecture is to examine how the courts have been holding both the governments and the corporate sector to account. I'll start with the government accountability. So the government of a polity needs to take the lead in setting and implementing the strategic policy and legal frameworks that are needed for effective climate action. There are three arms of government. The legislature needs to enact laws to require the needed climate action. And the executive needs to execute these laws and implement policies for the needed climate action. And the third arm of government, the judiciary, needs to hold both the legislature and the executive accountable for discharging these responsibilities. Let me start with the legislature's accountability. And I've grouped the litigation in two categories. First, where the legislature has failed to make legislation as they were required to do by law. Or secondly, where they do make legislation, but they do so contrary to law. Let's start with the first category of the failure to make legislation. And I'll give two examples. So the legislature may fail to make delegated or subordinate legislation, such as regulations or rules, in breach of some legal duty to do so. The first case I wish to refer to is one from South Africa earlier this year. There is an area in the high veld in South Africa. It suffers from high levels of air pollution from the mining and combustion of fossil fuels, which of course gives rise to greenhouse gas emissions. The air quality there is very poor. There was an air quality management plan adopted, and it aimed to reduce air pollution to a level that would comply with national standards under legislation. However, the pollution continued and there was a challenge. It was said that the poor air quality violated the constitutional right to a clean and healthy environment. And secondly, they said that the relevant minister was obliged to promulgate regulations to implement and enforce this high veld plan. The High Court of South Africa agreed with the applicants. It found that the air pollution breached the environmental constitutional right, but more importantly for this lecture, that the minister had a legal duty to set regulations to reduce the pollution under the high veld plan. And so the court directed the minister to make those regulations within 12 months and set out a number of issues that the minister had to consider when making that regulation. My second example is one, which is a well-known one, in the United States, of Massachusetts against the American Environment Protection Agency. Massachusetts, amongst other plaintiffs, had petitioned the EPA to make a rule under the Clean Air Act to regulate greenhouse gas emissions from new motor vehicles. The US EPA had denied the petition in the mistaken belief that it did not have authority under the Clean Air Act to regulate greenhouse gas emissions because the greenhouse gases were not an air pollutant. That case went to the highest court, the US Supreme Court, and that court held that greenhouse gases did fit within the Clean Air Act's sweeping and capacious definition of an air pollutant. And therefore, the EPA was authorized under the Clean Air Act to regulate greenhouse gas emissions. And so the court remanded the proceedings to the EPA to determine the rulemaking petition. Now, ultimately, the EPA did make a number of rules, not only regulating the greenhouse gas emissions from new motor vehicles, but also, as I'll come to later, from the coal-fired, gas-fired power stations. My next category is where the legislation is made, but it breaches the law in some respects. And I'll give two examples, both from Germany. The first case is Neubauer case. And in this case, the plaintiffs challenged the constitutionality of Germany's Climate Protection Act. It was said that that act set inadequate greenhouse gas emission targets. And the German Constitutional Court agreed. It said that by setting inadequate targets in the short term, it deferred the action that was needed to later, after 2030, which would affect future generations. And that said, that placed an unreasonable burden on future generations to take the needed action. So it struck down the Climate Protection Act as being infringing the constitutional protection for future generations. Subsequently, the German Parliament has enacted a new Climate Protection Act. But that act has itself been the subject of challenge in the current proceedings of Steinmetz against Germany. There, it is said that the new targets in the updated Climate Protection Act fail to have proper regard to climate science. And they argue that the court should yet again strike down as unconstitutional the updated Climate Protection Act. That concludes what I want to say about the legislature's responsibility and accountability. Let me now turn to the executive government's accountability. And I'll group the cases in 8 categories. 5 of them will deal with climate policy, 2 will deal with taking or not taking climate action, and 1 will deal with the enforcement of the law. Starting with the first of my 5 categories dealing with climate policy. In this category, it's where the executive government fails to adopt a policy that it is required by law to adopt. And the example is a case that I decided in New South Wales. Under the relevant pollution legislation, there was a statutory duty on the New South Wales EPA to develop environmental quality objectives, guidelines, and policies to ensure environment protection. And the question was whether that duty encompassed a duty to develop policies to protect the environment from climate change. And secondly, if so, has the EPA complied with that statutory duty? I held that the duty did include an obligation to protect the environment from climate change. I said that at the current time and in the place of New South Wales, the threat to the environment of climate change is of sufficiently great magnitude and sufficiently great impact as to be one against which the environment needs to be protected. I found that the EPA had failed to perform this duty to prepare the necessary policies to protect the environment from climate change, and I issued an order in the nature of mandamus compelling the government to prepare such policies, and the government is now doing that. My second category dealing with policies is where the executive government does adopt a rule in this case, but that rule was not authorized by statute. And the case I'm going to give to illustrate this proposition is the very recent case decided on 30 June this year of West Virginia and the Environmental Protection Agency in the United States. As I said earlier, following the Massachusetts and EPA decision, the US EPA promulgated a number of rules, one of which was the Clean Power Plan rule, which sought to reduce the carbon dioxide emissions from existing coal-fired and natural gas-fired power plants. It sought to do so in 3 ways. The first way focused on the existing power plants, and it sought for those power plants to undertake to burn coal more cleanly and therefore reduce the greenhouse gas emissions. The second and third way were to effect what is referred to as generation shifting. That is, it was to shift generation from existing coal-fired power plants to, firstly, gas-fired power plants, and secondly, from both coal and gas-fired power plants to renewable energy sources. That was challenged, and the EPA cited a Section 111 of the Clean Air Act as providing the necessary authorization to make that Clean Power Plan rule. So under that section, the EPA could determine the best system of emission reduction that has been adequately demonstrated for the existing kind, for the kind of existing source. But that question was, did that particular section authorize this generation shifting approach, that's the second and third steps in the Clean Power Plan? And the majority of the Supreme Court held that it didn't, and the minority held that it did. In the majority's view, they said that where there is an extraordinary case where the regulatory body appropriates to itself wide powers, then the regulatory authority needs to show clear congressional authorization to exercise the power that it has exercised. And the majority held that the generation shifting approach in the Clean Power Plan was such a transformative expansion of the EPA's authority that's every reason to hesitate before concluding that Congress meant to confer on the EPA the authority that it claimed under Section 111 of the Clean Air Act. The minority disagreed. It said under Section 111, the EPA was entitled to determine what was the best system of emission reduction, and that was the most effective and efficient way to reduce power plants' emissions, and the EPA had decided it was the generation shifting approach. And the minority held that that was within power. My next category about adopting a policy is where the executive government adopts a policy, but it's contrary to the legislation pursuant to which the policy was adopted. And my example is the Irish case of Friends of the Irish Environment. There, the Irish government had adopted a national mitigation plan under the Climate Action and Low Carbon Development Act of Ireland. It was said that that plan was not authorised by that act. And the Irish Supreme Court agreed. It said that the National Mitigation Plan fell short of the sort of specificity that the act required, because a reasonable reader of the plan could not understand how Ireland would achieve its 2050 goals, and a compliant plan must be sufficiently specific as to the policy over the whole period to 2050. The next case, which I'm only going to touch upon quickly, is a very recent case of the High Court in the United Kingdom. There, Friends of the Earth and Client Earth and another group of environmental organisations and campaigners challenged the net zero strategy that had been made under the Climate Change Act of 2008. Now, there are two provisions of relevance in that act. Section 13 imposed a duty on the Secretary of State to prepare such proposals and policies as would enable the carbon budgets that had been set under the Act to be met. And Section 14 required the Secretary of State to lay before Parliament a report that set out those proposals and policies that had been adopted, and to show how the carbon budget would be met. And it was the net zero strategy purported to be to set those proposals and policies under Section 13 and to be the report to Parliament under Section 14. Now, the High Court held that net zero policy did neither. As to the breach of Section 13, it was said that the Secretary of State didn't discharge his duty in fixing the proposals and policies because he had insufficient briefing materials before him to form the requisite view. And the the net zero strategy didn't comply with Section 14 because, again, it didn't set out the analysis that was necessary to show how the proposals and policies would achieve the relevant carbon budget. And so there was an order that the Secretary of State do a revised report and put it before Parliament by next year. Let's come to the next category, and that is where the executive government does adopt climate policies which are according to law, but nevertheless fails to implement them. And I'm using the Pakistani case of Lagari. So there, the Pakistan government had adopted policies for adaptation to climate change, but hadn't implemented them. As a consequence, the petitioner said that that violated his fundamental rights. And the Lahore High Court agreed that the government's inaction in implementing the climate policies had breached the petitioner's fundamental rights, and the court ordered the establishment of a ad hoc climate change commission to implement the government's climate policies. The other way, of course, is that if there's implementation of the policy, but it is inadequate. And here I've taken an Indian case where the Indian national government adopted a national action plan on climate change, but because India is a federal system like Australia, the implementation of that depends upon each of the states also implementing that national action plan. The national government can't do it alone. And so here the National Green Tribunal directed the state governments to submit their individual climate action plans, which were consonant with the national action plan, and in order to implement the national plan. Now, the executive might adopt a policy or take climate action, but in doing so, they nevertheless breach the law in some other respect. And the example I'm going to give is that of the Urgenda litigation in the Netherlands. So there, the Urgenda Foundation challenged the Dutch government's climate policy in action, arguing that the failure of the Dutch government to take the required, deep and rapid reductions in greenhouse gas emissions led to two breaches of law. One, the duty of hazardous negligence under the Dutch Civil Code, and two, the various obligations under the European Convention on Human Rights. At first instance, in the district court in The Hague, the court found that there had been a breach of the law of hazardous negligence under the Dutch Civil Code. On appeal by the Dutch government, the Court of Appeal dismissed the Dutch government's appeal on the negligence ground, but then said that the district court's ruling should be upheld on another ground, being the breach of human rights under the European Convention on Human Rights. And then on a further appeal to the Supreme Court again upheld the Court of Appeal's decision, saying that the European Convention on Human Rights imposed a positive obligation on the Dutch government to take measures to prevent climate change. I now turn to the two categories dealing with climate action. And the first category is the failure to take adequate climate action. And I refer to a French case, Notre Affaire à Tout, against France. Now here, it was claimed that the French government's failure to implement proper measures to address climate change violated a statutory duty to act. It was claimed that this duty to act derived from the French Charter for the Environment, the European Convention on Human Rights, and the general principle of law providing the right of every person to live in a preserved climate system. And the Administrative Court of Paris agreed and said that the French government could be held responsible for failing to meet its own climate and carbon budget goals under both EU and national law. And the court ordered the state to take action to comply with its commitments to reduce greenhouse gas emissions. My second example is again a very a recent case, but this one was unsuccessful in the UK. So in this case, the Oil and Gas Authority set our plans about how to exploit the oil and gas reserves in the North Sea. And the challengers said that that was irrational and inconsistent with the UK's net zero target, to which I've earlier referred. But it was held that that claim was unsuccessful because it wouldn't necessarily result in increased emissions, and the Oil and Gas Authority had considered what it needed to do. The next one is, could there be said to be a duty at common law to take climate action in the exercise of statutory powers? I'm referring here to an Australian case. The Federal Environment Protection and Biodiversity Conservation Act allows the federal minister to approve coal mines and other greenhouse gas emitting sources. The question was there a duty of care imposed on the minister in exercising that statutory power to protect young people from the devastating effects of climate change? At first instance, the court held there was such a duty of care. However, on appeal, the full court held that there wasn't, for a variety of reasons. The decision essentially turns on the statutory construction of the Federal Environment Protection and Biodiversity Conservation Act, and it was held that the terms of that statute were inconsistent with the court finding that there is a common law duty of care governing the exercise of the statutory powers. That concept of a duty to take climate action will be the subject of another case brought by Torres Strait Islander people against the federal government on a different ground to the one which was the subject of the previous case in Sharma. I then come to the question about enforcement of climate law. And I'm referring to a case in England, the Richards case, where a 5-year-old boy lived next to a landfill site, and there were a number of emissions from the landfill. Hydrogen sulfide was the particular emissions that caused harm, but of course, landfill also has methane and other greenhouse gas emissions. And the UK High Court held that the relevant government agency was in breach of its statutory duty under the human rights legislation to protect the child's right to life and right to private and family life, and held that there was a positive operational duty on the Environment Agency to take action to enforce the law. That concludes what I wish to say about government accountability. I'll now just quickly touch upon corporate accountability. And of course, the corporate sector is the sector that's primarily responsible for global greenhouse gas emissions. And climate litigation seeks to influence corporate behaviour directly or indirectly. And I'll identify 5 ways, starting from the most direct and ending with the indirect. On the most direct, there may be a challenge to a corporation's high greenhouse gas emitting project. Secondly, there may be a challenge to a corporation's carbon intensive business. These are the so-called carbon majors. Thirdly, there may be a challenge to corporate governance, how the corporation manages climate-related risks of the business. Thirdly, there may be a challenge not to the corporation's activities, but to the corporation's purchasing up the supply chain or its selling of goods and services down the value chain. And finally, there may be challenges to the greenwashing or climate washing, false and misleading representations about the climate credentials of products and services. Starting with the accountability for high emitting projects. I refer here to a case that I decided about an open cut coal mine which would have, I found, unacceptable greenhouse gas emissions. And the emissions are particularly the scope 3 emissions. They're the downstream emissions from the combustion of the coal that has been mined. And I found that an open cut coal mine in this particular place would be in the wrong place at the wrong time. Wrong place because it had many social and environmental impacts on the people of the valley. But importantly for this lecture, wrong time because the greenhouse gas emissions of the coal mine and its coal product would increase global concentrations of greenhouse gases at a time when what is urgently needed in order to meet climate targets is a rapid and deep decrease in greenhouse gas emissions. And I said those dire consequences should be avoided. Coming to the carbon majors and the litigation which illustrates this accountability is the litigation in the Netherlands against the Royal Dutch Shell Group. So Miller de Foncy was brought action saying that the Shell Group had violated its duty of care under the Dutch law by emitting greenhouse gas emissions that contributed to climate change. And the Hague District Court upheld that claim and said that the Royal Dutch Shell Group had an obligation to reduce greenhouse gas emissions. It had a duty of care and it was obliged to reduce those emissions. And I won't go into the details of that, but the important point is that there was accountability for the Shell Group. There has been foreshadowed a further litigation by Client Earth against the Shell's board of directors, saying that the board of directors are in breach of their own duties for mismanaging Shell's climate risks, and they are not the strategy that the company is implementing is inadequate. I now come to accountability for climate-related risks. And there is increasingly being seen that directors must identify and manage climate risks, design and implement strategies, select and use appropriate standards, make accurate assessments and disclosures, and deliver on whatever commitments and targets the company adopts. An example of litigation is in Australia, where there was a member of a pension fund or a superannuation fund who was concerned that his pension fund had failed to disclose the climate-related business risks of the investments that the pension fund had made. Ultimately, that case settled because the pension fund agreed that it would change its strategy. It agreed that climate change is a material, direct and current financial risk to the superannuation fund, and that the trustee must consider that it must identify and manage these climate-related risks. Subsequently, this pension fund has divested from climate greenhouse gas causing industries. I now come to the supply and value chains. And so an example of the supply chain is the current litigation against the Casino supermarket chain in France. So there, they are sourcing their beef from Brazil and Colombia, but it's alleged that those farms have caused deforestation, which are carbon sinks, and therefore there is a impact in the supply chain. And so there's litigation against the Casino for its responsibility in that supply chain. In an Australian case, again, a case that I decided, a question was, did a coal mine or a gas operator, in this case it was a gas operator, Santos, have control in the supply chain and in the value chain? And I held that in certain circumstances, there may be responsibility for both the choice of electricity suppliers and the supply chain, but also in the downstream emissions in the value chain over end users. My last category is greenwashing or climate washing. And there's two cases I refer to which are current. One is against that same company, Santos, and it is alleged that their claims that gas is a clean fuel, provides clean energy, misrepresents the true effect on natural gas on climate change. And the second case is a case by Greenpeace in France against Total Energy. And again, it says that Total Energy's advertising campaign is misleading because it says that their claims of aiming for net zero by 2050 and to become a major player in the energy transition are false, and that the company's claims promoting the environmental virtues and transitional role of gas is also misleading. And so that case is still current. So finally, the judiciary, by holding governments and corporate sector to account, upholds the law, but also the rule of law. And so where the law promotes taking action to reduce greenhouse gas emissions by sources and to increase removal of greenhouse gases by sinks, then the judiciary's actions facilitate the achievement of effective climate action. Thank you, and I wish the rest of this important conference all the best success. Thank you.
Thank you so much, Honorable Justice Brian Preston, sir, for your keynote address. It was truly very, very informative. It was deep in knowledge. We could see the research and we could see the various features that you have included into it. I'm sure that it was enlightening for all the viewers. Now, I would like to request Ms. Hiral Shukla, Assistant Professor at Faculty of Law, to offer formal vote of thanks for this.
Sorry for the interruption. Before we go for the vote of thanks, would like to welcome Dr. Gitanjali. She was with us from the beginning as the Honorable Lordship was presenting. So we could see that she was backstage. Thank you so much, Dr. Gill, for joining. I welcome you on behalf of GLS University Faculty of Law. Now I think you can proceed, Hiral, for the vote of thanks.
A very good morning to everyone. I, Hiral Shukla, Assistant Professor, Faculty of Law, GLS University, would like to extend official vote of thanks. I would like to thank our chief guest of the event, Honorable Mr. Justice Brian Preston, Sir, Chief Judge, Land and Environment Court, New South Wales, Australia, for accepting our invitation and sparing the valuable time and shedding light on such a prevalent issue. I'm sure that it has definitely given a different perspective to all our august audience, and I surely believe that your thoughts have enlightened the minds of all. Thank you so much, sir. I would also like to thank Professor Barbara Propozo, ma'am, Dr. Mohammed Benassi, sir, and Professor Gitanjali Gill, ma'am, for joining the inaugural ceremony of the International Conference on Climate Change, Governance and Law. Thank you so much. I would also like to express my gratitude to the head of the family, Dr. Sudhir Nanavati, sir, President, GLS University, and Senior Advocate in High Court of Gujarat and Supreme Court of India. Sir, we are deeply honored for sparing your valuable time and for encouraging us to organize such events. A special thanks to Dr. Chandni Kapadia, ma'am, Executive Director, GLS University, for all the support and guidance. Thank you so much, ma'am. I would also like to thank Dr. Dharmesh Shah, sir, Registrar, GLS University, for always being supportive. My special thanks to the pillar of Faculty of Law, Dr. Mayuri Pandya, ma'am, Director of the Institute, for her constant support to make this international conference a success and for all the strength that you always render to us. Thank you so much, ma'am, for being there for us. Lastly, a big thanks to all the viewers and participants for joining the inaugural ceremony and all the teaching and non-teaching staff as well as central office and the technical team for their meticulous hard work for making this event a success. Thank you all so much. Namaste. Ma'am, you are on mute.
With that, our inaugural ceremony ends here, and with the permission of all the dignitaries present over here virtually, we will be officially starting with our plenary session work one of International Conference on Climate Change, Governance and Law.
Thank you.
Thank you so much, everyone. We are ending the broadcast.